Hi, everybody. I'm Samantha Wolfe from the Law Offices of Samantha Wolfe. Welcome to our lunchtime seminar. Excited that you're all here. And today we're going to talk about minors, children, planning that you can do as part of your estate planning. And like most of the inspiration that I get, a lot of it comes from my own family. I have a lot of nieces and nephews. I have now 3 nieces and 3 nephews. My sister just had a baby yesterday, so we're excited to have a new addition to the family. So when we gather around for any type of family function, I'm looking at all of my sisters and their children, and I'm thinking, we can help a lot of clients who might not be planning for the second half of life necessarily, but might have minor children. And how do we address that in the estate plan? So I'm going to do that today during the lunchtime hour here. And we do have monthly virtual seminars every month, and you're welcome to check out our YouTube channel. We do record them and then post all of our videos up on our YouTube channel where you can check out our website. So with that being said, let me share my screen so that we can start our PowerPoint here. Okay, so as I said, we're the law offices of Samantha Wolfe. We're located at 20 East 6th Street, Suite 206 in Waynesboro, and you can reach us at 717-655-2676. And we always offer initial consultations, so if you're listening to this or you happen to check out any of our other videos and you have specific questions, you're always welcome to give us a call. We'd be happy to chat with you. Whoops. Okay, here we go. So here is a copy of our mission statement. So we feel very strongly at our office that we want to make sure that we're doing the best that we can for our clients. And that includes collaborating with their accountant, financial advisors, or any other trusted professional that they have that they want to incorporate into their estate plan. We also like to advocate in times of crisis for families. We really try to reinforce any estate plans with asset protection strategies. And we really do want to make sure that we have efficient administration upon somebody's death. So today we get to talk about the fact that they're going back to school. So I always see everybody's going back to school pictures on Facebook, and it's that time of year. So we thought it was a great time to really focus on families that do have minor children. So today we're going to talk about planning specifically for families that have minor children. But we are going to break it up into 2 different sections because anytime we're talking about kids, we're talking about minor children, and then there's also, of course, the adult children. So most of the presentation will be focused on planning if you have minor children, but we are going to talk a little bit about if you're an adult child, how do you plan? Or for example, if my parents wanted to plan as part of their estate plan for us, their daughters, we would be considered adult children. So I did want to touch on that a little bit. So the first thing that we're going to go over is how do you prepare for future generations. So there are a couple of different ways that we like to make sure clients are prepared. So this first one is an area that I think that attorneys need to do a better job at educating people about, and that's the standby guardianship form. So we're going to talk a lot about guardians and how that comes into play as part of your estate plan. But a standby guardianship is one of the first things that you should make sure that you have. And I'm going to go over how you do that, and I'm even going to show you an example of what we do here at our office. And a standby guardianship is actually a statute in Pennsylvania that says that if you're a parent and you want to appoint somebody to be able to provide for your children, or the best example I always use is if my sisters and their spouses are traveling, maybe I'm watching the kids for the weekend, I might ask them to complete, if they feel comfortable, a standby guardianship form that will allow me, if I need to take one of my nieces or nephews to the doctors, to the hospital, any type of treatment like that. That's really what a standby guardianship is. We're also going to talk about the difference between a guardian and a custodian under someone's last will and testament. We're going to talk about 529 plans. We're going to talk about uniform transfers to minor accounts or UTMA accounts. And then we're going to talk about children's trusts. And we're going to talk about all of these in the context of when do you use them? Are there times that you need to have multiple of these different tools in your toolbox as part of your estate plan? So like I said, I'm excited to talk about it. We don't get to focus on families with young children a whole lot. And so I thought today would be fun to be able to do that. So standby guardianships. So this is a law in which you can actually legally allow someone to be able to provide for your children. they have a certain level of authority over your children, but it's not giving away all of your parental control. And usually it's for a specified period of time is what a standby guardianship form is. So this is a copy of what the statute, so it has the Pennsylvania code section there, and this is a copy of what the statute looks like when it's talking about standby guardianships. So this is a form, and I'm going to flip on to the next slide so you can see it's actually 2 pages. And so you fill it out here, and what you're doing is you're saying, during a specified period of time or for a specific reason, I'm going to designate a certain person. I'm going to appoint them as a standby guardian for my minor children. So like I said, most of the time I see this often used if husband and wife are traveling. And I actually give a copy of this blank to my clients, as well as I'm happy to email them a PDF of it as well. And the reason why is this way, if my sister and her husband go out of town this weekend and they want me to watch their kids this weekend, but maybe a month from now they're going to have my parents watch the kids, you can really designate what period of time are we talking about. So in this case, it might be 60 days after, from the time you sign it, you might be saying for those 60 days. You can actually shorten it if you want to. So you can say just from Friday to Sunday. And what you're doing is you're saying during this period of time, you're giving this person the ability to legally consent to certain things for the child. So I like to have this, like I said, we just print them off, and what happens is you have to witness and sign it, and then you want to get the signature of the standby guardian that you're appointing. And so this is a document, again, it's different from the guardian that you're naming in your will. So the guardian that you're appointing in your will, that's somebody who's going to permanently be in charge of that child if something should happen to you. So this is just a standby guardian, which just means that it's not permanent, it's just for a specified period of time. So I'd like to think that I'm the favorite aunt or the favorite sister in the house or in our family, and that everybody, of course, would want to appoint me as the guardian of their kids. But in reality, they might say, you know what, this is the person who, if something happened and we were no longer here, who we'd want to be the permanent guardian, but Sam's going to watch the kids for this weekend. So during that specified period of time, that's when this document comes into play. So know that you're going to have this document that you can use during certain periods of time. And then in your will, you're going to have who you're naming as the permanent guardian if something should happen to both spouses. So you actually want to be using them at the same time, especially if it's a different person that you're appointing as your standby guardian for that specified time, if that individual is different from who you're permanently appointing in your will. So these documents, the standby guardianship and the guardian that you're appointing under your will, they would be used at the same time. And again, this form that we have, you can print off and use it. So when you're done, when that specified period of time is done, you can shred it, get rid of it, and then use a new one and fill it in appropriately for the next event in your life that you may be out of town. So again, we always like to email this to our clients who have children under the age of 18, just so they have it on hand and can print it for whatever they would need. So that's our standby guardianship form. Why would you need one? So we've seen it in a couple of different cases. So some of them are happy things, like maybe a family's going out of town, or a husband and wife are going out of town, they're going to be traveling. And then we also see it, sometimes you might have a parent going in for a medical procedure, especially if it's a single parent, and they're going to be under anesthesia, and so they want to make sure that during that period of time, somebody can make decisions for their kids if they're unable to do that. We also see it in situations where there might be an incarceration or a deportation. So those are times that we've seen it used. Most often, it's the traveling and out of town. And again, we just give a copy of a blank document to our clients so that they can use it when they're leaving and out of town. Sometimes I'll get an email that says, hey, we're going out of town. Can you just take a peek at what we filled out and make sure that it's done correctly? And I'm happy to do that. So these are reasons why you would want to do the standby guardianship form. So most standby guardianship laws, including Pennsylvania, allow a parent to designate a certain person to be the guardian for his or her children, and it can go in effect during the lifetime. So again, that's that form where you're still there as the parent, being able to make decisions, but maybe you're just going to be out of town for a period of time. So, and then the parent still retains control over that guardianship, and they can determine when it starts and when it finishes, or they can withdraw the authority at any time. So how do you do that? So the first way you can do it is by a court hearing, but of course, nobody really wants to do that. The second way is through written designation, and that's why having a permanent guardian named in your will, as well as having these standby guardianship forms that you can use, that's why they're so important, because that way you don't have to petition a judge, you don't have to have somebody give you the right to appoint this person. You are giving them the right and the legal authority to be able to make decisions for your children. Okay, so that was the standby guardianship. So again, you're going to have a standby guardianship form that you're going to use in addition to your last will and testament, which we always recommend that clients who have children under the age of 18 have a will. And the main reason we recommend is so that if you have underage children, who is going to care for those children? So know that the standby guardianship you're going to use in addition to your last will and testament. So when we have younger families with younger children, the first thing that we talk about is the last will and testament and how does this work? A couple of things about the will. So the first is that you may designate your children who are minors as contingent beneficiaries. So a lot of times I see husband and wife, they appoint each other as the primary beneficiary on certain retirement or investment accounts. And then they may want to name their children, their minor children, as contingent beneficiaries. And so, and we're going to get to this in a second. My preference is when you have minor children and you want to leave large sums of money to them, that you use a trust to do that. But sometimes either people don't need one because there aren't a whole lot of assets there. They can't afford to do one. The expense of creating a trust can be a lot. And so what we do in that case is in our will document, we're able to name a custodian and a guardian. And the custodial clause in the will, we make sure that it encompasses not only assets that pass through the will, but to the extent that you have a beneficiary designation for a non-probate assets or retirement or life insurance, we also make sure that our language in the will says that this is who you would want to be able to handle those funds until the child reaches age 18. Or in Pennsylvania, you can go all the way up to 25. So the last will and testament is just a written document that says when I die, this is how I want my assets to be distributed. Of course, you're going to have an executor or what we call a personal representative that's going to make sure the assets get where they need to, pay all the appropriate tax, file all the appropriate returns. And then the will also allows you to designate a custodian and a guardian. And that can be a different person than who your executor is. So for example, in my family, I'm going to use my sister as an example. So she has 2 kids. So she has 3 wonderful sisters. So she may name one of us as the executor, knowing that, they're really good with finances. They'll make sure that everything gets done appropriately. But, the kids really do feel more comfortable if they had to live somewhere living with this individual. So that's why we make the distinction between a custodian and a guardian in the will. And it's really important that you have that. So a custodian is the person who physically handles the funds. So a custodian would be handling, making investment decisions, anything that you would be doing with your investments, that's the custodian's job. And like I said, you can name a custodian up until the child reaches age 25. Now, a guardian is only till 18. So in the will, you're going to have a guardian up until the child reaches the age of 18, who the child physically is going to be living with or going to be residing with. That would be the guardian. The custodian is who's handling the funds. And in Pennsylvania, our UTMA statute allows it up until the age of 25. Now you can do anywhere between 18 and 25. So sometimes people say 21, had some people pick 22, but I would say most often people either pick 18 or 25. So either the minimum or the maximum. The other interesting thing in Pennsylvania that I've seen in wills that attorneys may not realize is that you can name multiple guardians. So for example, if you had a husband and wife that you wanted to be the guardian of the kids, you may say, for example, I could say my sister and her husband as the guardian, but a custodian, you can only name one at a time. So when you have a custodial clause, you need to make sure that it says I'm appointing this person, and then if this person can't serve, then it's this individual. So you want to make sure you're only naming one person at a time, because by law in Pennsylvania, you can't have multiple custodians. It has to be one person. That person can't serve, then it's another individual. Like I said, you can have the custodian and the guardian be the same individual, or you might have it be 2 different individuals. So it's not uncommon for a family to say, this child is really good with kids and that's who I'd want my children to live with, but they might not be the best with finances. And so maybe I'll have this other family member actually be in charge of the funds. So again, it's all about what you feel comfortable with. I would say about 80% of the families that come in that are providing for a custodian or a guardian, they do pick the same individuals to serve as both the custodian and the guardian. But again, you don't have to do that. In some ways, it allows some nice checks and balances if you do have it be different people. So again, you have the guardians physically, where's the child going to be? And the custodian is financially who's providing for that child. And again, that can go up to age 25 where the guardian is only till age 18. And then in addition, you obviously have the standby guardianship form that would just be if you're out of town and maybe the kids are staying with a family friend for that weekend. So again, you have the standby guardianship form in addition to the last will and testament. The other thing I think that is worth mentioning here is that depending on the financial institution that you work with, you may have a retirement account or a life insurance policy, and you may be naming minor children, but in the policy, in the contract itself, they may have in there that if they're underage beneficiaries, then it pays to the custodian under the will, or it may say it pays to, this particular individual, or it has to go in trust to them. So you always want to make sure that when you're talking with your attorney and your financial advisor, that you're asking those questions. Does this contract provide for underage kids? Do I need to make sure to mention that in the will? And I always err on the side of caution. I think you should always have a custodian named in the will regardless. But I did learn that certain companies do have inside the contract their own set of rules about how it gets handled. And you just want to make sure that you're aware of that when you're talking to your financial advisor. Okay, so we covered standby guardianship forms. We covered the will with the guardian and the custodian under the last will and testament. So those are all when you die, or if you're not able to make decisions, who can be able to make decisions for your kids. So that's kind of the depressing part, I guess, of the presentation. So the more uplifting things are the things we're going to talk about now. So the will, the standby guardianship forms, all very, very important, and you need to make sure you have them. You also can do 529 plans. So we're going to talk a little bit about 529 plans. We're going to talk about the UTMA accounts, and then we're going to talk about some children's trusts. These are all fun and exciting ways that you can help plan for any minor children that you have. And this does apply. So we're going to talk about a lot of these concepts, and it does apply to grandchildren as well. So I wanted to make sure to preface that for those of you who are on the virtual seminar who may have grandkids. Wanted to make sure to mention that. The other thing, real quickly, before we move to 529 plans, the will also know that if you do have grandkids, and for example, in my family, like I said, there are 4 of us. I have 3 sisters. They all have children. And so when I was helping my parents with their estate plan and they said, we want everything divided among the 4 children, I had to ask the question, well, what happens if one of us would predecease you? And then my parents had to say, well, I would want their share to go to their children. Because again, you want to make sure you're specifying that. And then what my parents could do is they could say who would be in charge of those funds. So if for some reason, maybe they didn't want it to go to a son-in-law to be able to make decisions for their grandkids, they could say, well, I want it to go to my daughter's children equally if something should happen to my daughter, but I'm actually going to name this person as a custodian until those grandkids reach age. And again, you can do 18 or all the way up to 25. So if you're on this seminar and maybe you don't have minor children anymore, but you do have grandkids or great grandkids, and you're either providing for them directly in the will, or you're using per stirpes language, which just means that you're saying, if one of my children dies, I want it to go to their children or my grandkids, for example. You want to make sure that you have the custodial clause. You don't need the guardianship clause because it's not your job to say who physically is responsible for those kids, but you still want the custodial clause because you want to be able to say, if my child dies and it's going to my grandkids, this is who I want to be in charge of those funds. So most of the time, and I can use my own family as an example, most of the time when we have clients come in, they're going to say the surviving parent. But I'll use my one sister, Jess, who actually works in my office and is on the call. She's married to a wonderful guy. My parents love him. But if something happened to my sister, I was talking to my parents and I said, I know we love Josh, but if something would happen to Jess, you may not want it Josh should be in charge of the funds for the underage kids. And that's just simply because if Josh would get remarried and maybe he'd either have more children or the influence of the new spouse, you may just not want that. You may want it to still stay in the family, even as far as who's making decisions for the grandkids. And so what I told my parents is it's okay to say that you don't want it to be the surviving parent. It's okay if you say, I want this child, or if you just have two children, you could say my surviving child can be the custodian. So just because there might be a surviving parent does not mean that that surviving parent needs to be the custodian for those children. And it's perfectly acceptable. There are a lot of reasons why you don't want to do that. Again, the checks and the balances. So I always like to talk to people about that. And I would say almost everyone opts to not have it be the surviving spouse, to have it be like a surviving child or other trusted family member, just because you don't know as time goes on what those influences would be on a surviving child. So I like to use that as an example because I think it's important for anybody who has grandchildren to know that you should provide that way as well. I have a bug that's flying around. Okay, sorry about that. All right, so let's move on to 529 plans. So 529 plans, it's a great way to help provide for children or grandchildren. The nice thing about 529 plans are they're good nationwide. Anyone can open a 529 plan. There's some great tax benefits. The plans do have a lot of flexibility, and it does allow you to stay in control of the account. So these are some reasons why you would want to do a 529 plan. Now, that being said, I just wanted to pause here. There are also some reasons why you don't want to do a 529 plan. One of those, and I just mentioned this because we do have some people on the virtual seminar who are listening and they're of the age where they're providing for their grandkids. And so they may say, well, should I set up a 529 plan? And I always like to caution people, the downside of 529 plans, if you're doing it for your grandchildren, is if you're going to set it up and you're the owner, it is available for long-term care costs. So you want to make sure you're accounting for that when you're thinking about nursing home costs and whether or not those assets are available. So I wanted to make sure to mention that. That being said, what is a 529 plan? So it's a tax advantage savings plan that's designed to encourage savings for future education costs. And there are two main types. There's a prepaid tuition plan, and then there's an education savings plan. So we have a lot of grandparents or parents come in who want to start saving for those minor children for any future education costs. And so 529 plan is a great tax way to do that. Now, again, there's a lot of reasons why you might not want to do it. One of those is being the long-term care cost concern, but it is still a great vehicle if that's not a concern that you have. So it's worth discussing and figuring out if it fits into your estate plan. So who can contribute? So anybody can contribute to a 529 plan. So if my parents set one up for the grandkids, anybody, including I could also, for example, my parents set it up, I could contribute to that same 529 plan that they've set up. Now, the reason why you might not want to contribute to an already existing 529 plan is because of the owner of the 529 plan. So again, the owner has the control about who the beneficiary would be, how those funds are invested. So that would be a reason why you wouldn't want to contribute to a 529 plan that someone else had created. But the nice thing is if you yourself don't want to set up a 529 plan because you are just contributing a one-time thing or you're contributing a small amount every year, then the nice thing is anybody can contribute. And that would be grandparents, aunts, uncles, cousins, even a complete stranger could contribute to a 529 plan. So you need to know the account number, the name of the beneficiary, and the account owner in order to be able to contribute to a 529 plan. How much can you contribute? Good news is there's no annual limits, unlike certain other investments that we'll talk about. However, the cap that you're going to want to keep in mind is the annual gift exclusion, and that's $15,000 in 2021. So it started off at 10. So a lot of times I have people come in and they say, well, I can set up 10,000 in a 529 plan. That 10,000 has now been adjusted for inflation. So it is now 15,000 that you can contribute. And if you're a husband and wife, it's actually 30 because each of you can contribute that 15. Now, the one thing I will tell you, if you're a husband and wife, I always encourage people to do 2 separate checks where each one of you signs it, even if it's from a joint account. And the reason is because if you're a husband and wife and you're contributing to a 529 plan and you do it as one check and you just put 30,000 and you contribute it into the account, technically you do have to file a gift tax return, a Form 709, in order to explain that you're splitting the gift. So if we have a husband and wife and they're both contributing the maximum amount, the $15,000, we just have them write 2 different checks and sign them that way. The $15,000 does not count against your lifetime amount. So when we're talking about the gift exclusion, the 11 million, know that everybody gets the 15,000. It doesn't count, doesn't eat away. So I wanted to make sure to mention that. So it will not count against that. The only time it starts counting towards your 11.7 million is if you go over 15,000 in any one year. Then the amount in excess will start decreasing that 11.7 million. The other important thing to know is that just looking ahead, we know that there might be some tax changes that are coming. So one of the things that might change is that the 11.7 may drop to 3.5. The other thing that may change that we've seen in the tax proposals is that there might no longer be the 15,000 per individual. So my parents, like I said, they have 4 daughters. If they wanted to, they could give each of us 15, and as a married couple, that would be 30,000. One of the proposed changes is that it would cap it so that instead of it being 15 per donee, person who receives it or recipient, it may be capped to 20,000 per donor every year. So that's something to keep in mind when you have these 529 plans and you're contributing annually. You do want to pay attention to whatever the gift exclusion is. So right now it's 15,000. We'll see what happens in the next couple of months to know whether that amount adjusts at all. The other thing to know is that you can front load a 529 plan. So to the extent that you may say, I want to make a gift of, 50,000 into it. What you can do is you can take the 15,000, multiply it by the 5 years. So it would allow you to front load for a beneficiary 75,000. Now, what that means though, is during the 5 years that you front loaded or put it all in the first year, you can't make additional gifts and claim that that's your annual exclusion for that particular beneficiary. So if you front load it with 75,000 in the first year, in year 2, you can't decide to give 15,000 to that beneficiary and think that's going to count for your annual exclusion. So if you do that, if you front load it, you have to know that that beneficiary can't receive the annual exclusion amount again during those 5 years. Otherwise, it counts toward your gifting amount, the 11.7, or if it drops to the 3.5 million. So just keep that in mind that when you front load, then you're kind of capped until you're past that period. How does it affect financial aid? So that's a good question. And this all depends on who is the owner. So if a dependent student or one of their parents owns a 529 plan, then there is minimal impact on the student's financial aid eligibility, but there may be greater impact when a grandparent or other third party owns the account. So you have to make sure that you're thinking through all of these things about who is owning it and whether or not it's going to affect any financial aid that the student or grandchild or child may be receiving. So that's one thing that we wanted to make sure to talk about. Let's move on. Thank you, everybody, for hanging with me. Okay, so what happens if my child doesn't go to college? So remember, we're talking in the context of a 529 plan here. So that's important to know because a 529 plan is designed to pay for educational things. So it's important to know there's a penalty if you withdraw and it's not for education for the beneficiary you designated. So the penalty is waived if the beneficiary happens to receive a tax-free scholarship. So we're always hoping that students are able to qualify for some type of scholarship. And if that's the case, then the penalty is waived if you're withdrawing the funds. Second reason would be if the beneficiary attends a U.S. military academy, then the penalty is waived if you're withdrawing from a 529 plan. Or if the beneficiary would become disabled or would pass away, then the penalty is waived when you withdraw from a 529 plan. What happens if there's any unused money in the 529 plan? So the good news is you can change who the beneficiary is. So you could actually change it to another member, another family member who would qualify. So you just change one beneficiary to the other. It's still going to be used for educational things. You can also hold the funds in the account if the current beneficiary wants to attend a grad school. So again, depending on what type of scholarships or what type of funding or how they're qualifying, these 529 plans can still be used for graduate level training or education. The other thing too is that you can roll over a 529 into an ABLE account, and this is really important in Pennsylvania that you can have an ABLE account. That would be if you had a beneficiary with special needs. You could, because you don't want to have a 529 plan potentially to jeopardize their benefits, you could roll it over into an ABLE account that Pennsylvania does allow you to have now. And then the last 2 points are just income tax things. So since January 1st of 2018, parents can have the option to withdraw up to $10,000 in tax-free 529 withdrawals if it's K through 12 tuition. The other way that we can get it out, the unused money, is that since January 1st, 2019, qualified distributions from a 529 plan can repay up to $10,000 in student loans per borrower for both the beneficiary and the beneficiary siblings. So again, if somebody would get through school and there's funds left over in the 529 plan, that would be really important to be able to use it. The disadvantages. So the one disadvantage is there are limited investment options with a 529 plan, and there are some fees associated with the plan, and that's just linked to those certain investments. And there's not a whole lot you can do about that. There is a 10% penalty for non-qualified withdrawals. And so it's important to know with a 529 plan what's considered a qualified expense. So tuition and fees, any college participating in financial aid with the Department of Education, or any community colleges, universities, trade schools, and graduate institutions would be eligible for you to be able to use these funds for tuition. Secondly, it can be used for room and board for students who are enrolled for at least half-time basis. It can be used for textbooks. It can be used for computer equipment and necessary supplies for that student. It's also able to be used for anything that would be needed for those that have special needs. So these would all be considered qualified expenses that the 529 plan, those funds could be used for. Okay, non-qualified expenses. What can't you use the funds for? Because if you use them for this, then there will be a penalty. So any transportation costs, any student loan expenses for the individual, any insurance or medical expenses, any fitness memberships, or any school-sponsored clubs. The funds in the 529 plan cannot be used for those expenses. Okay, so that covered the 529 plan. So we've gone over the standby guardianship forms. We've gone under the will and the difference between a custodian and a guardian. We talked about 529 plans. Let's talk a little bit about the UTMA account. So when attorneys or financial advisors refer to UTMA, that's the Uniform Transfers to Minor Act. That is an act that a lot of states enacted that allows you to set up accounts for minor children. And so we wanted to go over what the Pennsylvania requirements are. So again, it's Uniform Transfers to Minor, and it allows a minor to receive gifts without the aid of a guardian or a trustee. And the minor can avoid tax consequences until they reach the legal age in that state. And then the donor can also name a custodian who would have the fiduciary duty to manage and invest the property on behalf of that minor until that minor becomes of legal age. So again, Pennsylvania, that's where we're able to go all the way up to 25, because Pennsylvania's UTMA account rules in Pennsylvania allow us to name a custodian up through age 25. Again, you can stop at age 18, or you can pick any age in between 18 and 25. So what are the pros and the cons? So the main advantage of using an UTMA is that the money that you contribute into the account is exempt from paying gift tax as long as it's below the annual exclusion amount, which, like we talked about, is the $15,000 per year. And then any income earned on the amount contributed is taxed at the tax rate of the minor that is receiving those funds. So I actually have some accounts set up for my nieces and nephews, and that's one of the things that when I was working with my fantastic accountants, they had said, you don't have to worry about that, claiming that income, that's actually for those beneficiaries. So it is important, though, to keep in mind, because as those beneficiaries age and get older, they may have jobs where it does make a difference what is in that UTMA account and what the interest and dividends or whatever is earning inside that account. And the one thing that you have to be careful about with an UTMA account is that it does make the recipient less eligible for any needs-based college scholarship programs and any other initiatives through the college that they're attending. So how does an UTMA account work? So an adult's going to open the UTMA account and contribute to it on behalf of the minor beneficiary. The custodian is going to manage the account until the minor becomes the age of majority in that state. And again, it's all state specific. In Pennsylvania, you can go up to 25 under the will. All UTMA account assets transfer to the beneficiary once they age of whatever that is. So actually, Tim and I are working on a state where there was an UTMA account opened, and the client that we have is now in their late 30s, and it was never properly retitled. So what happened when dad passed away, it still had it in dad's name, but we knew it was an UTMA account based on the titling. And so what we actually had to do is, it's not going through dad's estate at that point. We needed to make sure to get the proper titling so that we didn't have to worry about anything estate-wise wrapping up dad's estate. So in that case, we were able to just transfer it because they were over the age of what the account required, which was 21. Okay, so the last thing I wanted to talk about from our slides that we initially opened with, which what ways can you plan for minor children? Because remember, we're looking at this through the lens of minor children. So one way that you can do it is through the UTMA accounts, through the 529 plans. You can use all of those great investing options. But another option is to use a children's trust. And the reason that I like children's trust is because you can go past the age of 25. So with the 529 plans and with the UTMA accounts, there's an age where you're no longer able to control those accounts. It goes to that beneficiary. So a children's trust allows you to go past the age of 25. So we have a lot of parents who may say, no, I actually want it to go to 30, 35, and 40, or even higher ages than that. So a children's trust is really important for that reason. It's also so important for those that have special needs, because as they get older, once they reach the age of majority, they may be able to independently qualify for benefits. And if you're going to be leaving assets to a child who has special needs, you want to leave it to them in a special needs trust so that they can still qualify for whatever benefit they're eligible for and receive the inheritance that you're trying to leave them. So that's why children's trust is important if you have somebody in your life who has special needs. It also allows the funds to be used for more than just educational expenses. So we saw some of the limitations for the 529 plan, what you can and cannot use those funds for. You don't have to worry about that with a children's trust. A children's trust allows you to specify exactly what you want those funds to be used for. It could be that you want payouts like 1/3, 1/2, and then the entire balance at certain ages. We see that a lot, and I would say the most common ages are 25, 30, 35. And they want the trust to pay out, and then at 35 it's completely done. We've also seen it where people set up a trust and they want a certain monetary amount to come out every year to the beneficiary, whether that be a percentage or a flat amount. It's going to come out every year to that beneficiary. And then the last way we've seen it is certain milestones. So graduation from college or high school, first job, buying a house, all of those you can set it up to coordinate with life events for the child. So it's more than just education. So we like that. The other reason we like it is because it does allow us to do more creditor protection. And that's creditor protection not just for the child. So if the child would get married and get divorced, would be in a car accident, would have any type of debt, it would protect against those creditors. But just as important, it protects it against the parent or the grandparent's creditors. And the biggest one we think of is a nursing home. So if you set up a children's trust, you can make it so the assets that you've transferred into that account are going to be protected against your long-term care costs. And that's just as important as making sure those funds get to the children. So it can be revocable. So we're going to talk a lot about the different types of trust, but the important thing to know is that if you're not worried about protecting against long-term care costs, but you have it for some other reason, meaning at certain ages or certain life events, you want it to pay out to the beneficiary, we can have it be revocable, and anybody can make any revisions that they want based on what the rules of the trust are. So for example, my parents could set up a trust that they can revoke it, they can change any parts of the terms of the trust while they're living. They could also, if they're setting it up for grandkids, allow their children to make revisions to it to the extent they want to after they've passed away. So know that children's trust can be very flexible and really address whatever specific needs that you need. You can also name a successor trustee. So once you're gone, who's in charge of those funds? Child can be the trustee at a certain age. So we just did one trust where we weren't sure what age mom and dad weren't quite clear about what age they would want child to be the trustee. So what we decided to do in that case was to name a trustee who could determine, based on their discretion and their close relationship with those minor children, when they were at an age that they could be able to serve as their own trustees. So we were allowed to be a little bit more flexible in the trusts. You can also do a limited power of appointment. That's what that LPOA stands for. And that's for when we're trying to think long term, generations down the line. So maybe my parents want to divide the estate and have it go in trust to each of the children, but they're not sure what their grandchildren are going to grow up to be, what their habits are going to be. And so they may allow each of their kids to have a limited power of appointment so they can appoint it to certain children. So if there is somebody who has developed bad habits or they don't want the money to go to, their children can always exercise this power of appointment and direct it to other specified individuals. And usually what we do is we just classify in whatever group. So it could be any other descendant of the client, for example. And then lastly, we can give the child withdrawal rights at certain ages. So again, 25, 30, 35, they can draw certain amounts out, or it can be at certain life events, or it can be a yearly percentage or a flat amount, depending if you've thought through all the tax ramifications of that. So it does allow us a lot of flexibility. I love trusts, and so children's trusts, I think, are a great way to make sure that your wishes are being fulfilled and satisfied in that way. Okay, so we talked about minor kids. So again, at the beginning, I said we were going to try to look at it from the lens of minor children, and then we were going to look at it as adult children, because I don't want to miss this opportunity to provide some information if you have adult children and you're trying to incorporate planning for them as part of your estate plan. So the important thing to know is that what we're really concerned about here is long-term care. So people are living longer. We are seeing more people, even if it's for a short period of time, either need care in the home at a skilled level, or maybe they actually need to go into a facility that's providing skilled level care. And so when we're trying to make sure our assets are going to our kids, we need to make sure we're addressing the long-term care aspects of it. So the average cost of long-term care in Pennsylvania is $11,099 per month. So for a year, that's $133,000. So what that means is that if you don't do anything to protect your assets, all of your assets would be available to be spent on that long-term care. And it's not that you don't want to use those funds to pay for your long-term care, but there may be certain reasons why you don't. So for example, you might have a spouse that you want to make sure that you're allowing certain funds, that they're not financially compromised. We had a situation where we had a child with special needs, and when dad passed away, we needed to make sure there were enough funds to provide for the son who was in his early 30s, who had special needs, because he's going to hopefully live, another 40 years. So we wanted to make sure there were enough funds there. So when we're talking about long-term care costs, we're talking about protecting assets so that your kids or your spouse, those adult children, are protected and the funds aren't all going to pay. The average cost of assisted living in Pennsylvania is $3,000 to $4,000 a month. It all depends on the facility. So this is important because a lot of times clients come in and they say, well, can I just gift the assets to my kids? And this is really important. There are two reasons why we wanted to talk about planning specific to adult children. So the first is because there is a look back period in Pennsylvania. This is important not just for the client, but also for the children, because if my parents said, well, I'm just going to transfer everything to my kids, and then I'll immediately qualify for Medicaid and I won't have to worry about those assets being available for care. The problem with that is that when my parents make that transfer, if it's within a 5-year look back period that they need care, they have just made my sisters and I financially responsible for their nursing home costs because they made that transfer. So that's why this is important. And I wanted to take a couple of slides just to talk about making sure you're planning for your adult children. You don't want to make large gifts directly to them outright, because it does make them in Pennsylvania financially liable for your long-term care costs. The cutoff in Pennsylvania is actually $500 a month. If you transfer more than $500 a month, and it's not $500 per person like it is for the gift exclusion, it's $500 for the giver, meaning my dad can only gift $500 a month. That's it. And he has to do it per month. He can't wait till the end of the year and say $500 times 12 months, I'm just going to write a check for the $6,000. He can't do that either. It has to be $500 or less every month. If it's $500 or more, then it's going to trigger a transfer penalty. And a transfer penalty is that for every $11,099 that you transfer, if you need care within 5 years, that's 1 month that you're not eligible for Medicaid. And so the 5 years is the maximum amount of time, but you can have a transfer penalty for less. If you transfer 100,000, you just take the 100,000 and you divide it by the $11,099. That would tell you how long you'd be ineligible for Medicaid to cover your costs. And that's what's important when you're trying to figure out, are you making your kids financially responsible for your long-term care costs? So here's a picture of my sisters and I couldn't help but put this in. I just want to point out that my sister Jess, who works in the office, she's the really disgruntled child in the front there with that awful face. She's sitting here laughing as I'm saying that. So I put this on here. This is my sisters and I. I'm the goofy one on the left with the little smirk there. So if my parents said, well, let's just add my kids' names to all of the assets and be done with it. And you can do that. The answer is yes, legally you can do that. But the problem with that is that when you do that, yep, go ahead, advance it. When you do that, it makes it available for all of the children's creditors. So that would be any divorce, any debt, any disability, or if one of us would pass away, then my parents are paying inheritance tax on their own asset. So we always like to make sure that we're talking to clients about the fact that you can add your kids' names to the deed or to any bank accounts, but you have to know that you're immediately making that asset then subject to their creditors. And you're immediately running the risk of having to pay inheritance tax on your own asset back. So inheritance tax in Pennsylvania, this is a chart that shows it. So any charitable organizations or government entities, there's no tax for that. If it's to a spouse, it's 0% tax. If it's to anyone in your line, so going up to parents, grandparents, or down to children and grandchildren, they're going to pay a 4.5% tax rate. Siblings will pay 12%, and any other beneficiary is going to pay 15%. Okay, so that just means that right now I don't have any children. So if I would pass away and I leave everything to my sisters, for example, they're going to pay a 12% tax. If I leave everything to my nieces or nephews, they're actually going to pay a 15% tax on that. And look at it the other way too. If we're talking about adding children's names to accounts, that could be problematic because if a child dies, it's 4.5% tax for mom and dad again. So how do you protect your assets and how do you protect your adult children? You can use a variety of trusts. So the one that's going to give you the protection against long-term care costs as well as your children's creditors is going to be the one that's on the bottom left, the irrevocable protector trust. Those are the trusts that we use to make sure that you have protection and your kids have protection. The other type that we use a lot when we're trying to make sure to protect for everybody is special needs trust. If we have a circumstance where a child or a grandchild has special needs, we're able to use those type of trusts. So this is just a picture of, we always like to do visuals that show what we're doing for clients. So this would be for a husband and wife. Maybe they have some real estate and then maybe they have an investment account where they take the interest and dividends off. And so if you have adult children and you're looking at how to plan to protect not only you, but them, these types of trusts are a great way to do it. And so we just have a picture there to kind of show this. And again, then you can have it when you die or when you and your spouse pass away and it's going to your kids, it can go in trust to them, which does protect it against their creditors. So if something would happen, whether it be a divorce or a car accident, those creditors cannot attach to that inheritance. And so that's why it's so important when you're thinking about planning for adult children to think through what are the potential creditors. Once you have it go outright to a child, there's nothing you can do to protect those assets. So that's why it's important for you to think about it as a parent. So again, the whole point of today was to talk about focusing on planning for children, whether it be a minor child or an adult child. So you need to think about it before you pass away because you want to make sure you have the proper structure set up there. Okay. The other thing I wanted to say is the next virtual seminar that we have is September 22nd. Can't believe we're already going to be in September. So September 22nd, it's over the noontime hours, so from 12 to 1 again, and we're going to fall back to the basics of businesses. And so that we're just going to talk about how do you set it up, what forms you need to file, what legal documentation do you need to have in place, who do you need to talk to. You can register by emailing Amy Meek at our office at meek@skwlawoffice.com. You can call us as well. You can also complete the registration form on our website. And right after this seminar, Amy's going to send out a survey. I do have to let you know, we did come up with some new survey questions. I know there for a while we've been sending the same ones to get some feedback. So these are a little bit different. So we'd appreciate any time you want to take to give us feedback. If you think of any other ideas that are helpful, you can always let us know. And I want to make sure everybody knows who's on here. The next seminar, virtual seminar that we have, I am committing to not having any technical difficulties. So whether that means I have to have Jess sitting right here next to me to do that, we're going to do that. So I really do appreciate you guys hanging in there. I'm sorry about that. I wish I was better with technology. For some reason, I press a button and things go crazy on my screen. So thank you, Jess, for being here and advancing the slides for me. So that being said, let's flip to the next one. I think, Jess, that's just questions, right? Yes. Okay, so I'm going to turn off the recording. Thank you, everybody, so much for being here. I'm Samantha at the law offices of Samantha Wolfe. You're always welcome to give us a call. Thank you.